Hello everyone, this is Torts and Damages, Law 323. I will be discussing Part 2 of the independent civil actions, which are fraud, physical injuries, neglect of duty, and the catch-all provision, which is Article 35 of the Civil Code. Part 1 will be discussed by my partner, Ms. Raquel Guay. Independent civil actions are those provided in Articles 32, 33, 34, and 2176 of the Civil Code of the Philippines. In the cases provided in these articles, the independent civil actions may be brought by the offended party. Independent civil actions may proceed independently of the criminal action and shall require only a preponderance of evidence. This is the principle of independent civil actions. It can proceed independently from the criminal action. The offended party may not have double recovery for the same act or omission charge in the criminal action. The offended party only gets the bigger reward. Article 32 provides for an independent civil action for damages for violation of civil and political rights. Any cases referred to in Article 32, whether or not the defendant's act or omission constitutes a criminal offense, the aggrieved party has a right to commence an entirely separate and distinct civil action for damages and for other. This civil action shall proceed independently of any criminal prosecution and may be proved by a preponderance of evidence. In Article 33, defamation here includes the crimes of libel and slander. Libel is written defamation while slander is oral defamation. The tort of fraud under this article includes cases which constitute the tort of deceit in England and the United States. The provision in Article 34 likewise states that the civil action shall be independent of any criminal proceedings, and a preponderance of evidence shall suffice to support such action. In this article of 2176, whenever it refers to fault or negligence, it covers not only acts not punishable by law, but also acts criminal in character, whether intentional and voluntary or negligent. Consequently, a separate civil action lies against the offender in a criminal action, whether or not he is criminally prosecuted and found guilty or acquitted, provided that the offended party is not allowed to recover damages on both actions and would be entitled only to the bigger award of the two actions, assuming that the awards made in the two cases vary. In fraud, the elements of deceits are: the defendant must have made false to the plaintiff, the representation uh, must be one of fact, the defendant must know that the representation is false or be reckless about whether it is false, the defendant must have acted on the false representation, the defendant must have intended that the false representation must be acted on, and lastly, the plaintiff must have suffered damage as a result of acting on the false representation. False representation contemplated in the first element can be made by spoken or written words. It can also be made by conduct. A representation is not confined to words or positive assertions, but may consist also of deeds, acts or artifices of a nature calculated to mislead another and thereby to allow the defendant to obtain undue advantage over them. The second element removes representation of matters of law from the ambit of the tort of deceit. The reason for the rule is that propositions of law are generally matters of public record to which the plaintiff and the defendant have equal access. In the case of heirs of Simon versus Elvin Chan, Eduardo Simon issued to Elvin Chan a land bank check payable to cash, knowing that at the time of issue, Eduardo did not have sufficient funds or credit with the Drawy Bank for payment. Eduardo Simon failed to pay Elvin Chan the amount of the check for full payment within 5 banking days after receiving said notice. After 3 years, respondent Chan commenced a civil action for the collection of the principal amount. Defendant Simon seeks to dismiss plaintiff's complaint for the reason that there is an alleged pendency of earlier criminal action. The issue is whether or not a separate civil action is proper notwithstanding the earlier criminal case for violation of Batas Pambansa Bilang 22. The Supreme Court held no. There is no independent civil action to recover the civil liability arising from the issuance of an unfunded check prohibited and punished under BP 22. In this case, the respondent's civil action to recover the amount of the unfunded check was not an independent civil action. This is clear from Rule 111 of the Rules of Court, which provides that the criminal action for violation of BP 22 shall be deemed to include the corresponding civil action. No reservation to file such civil action separately shall be allowed. In Consing versus People, Respondent Consing Jr. and his mother Cecilia de la Cruz represented to Plus Builders Incorporated that they are the true and lawful owner of a parcel of land. So PBI, relying on the representations, purchased the land. Later on, PBI discovered that Consing and his mother did not own the land. So as a result, PBI was ousted from the possession of the disputed land. PBI demanded from Consing and his mother to return the money initially paid but to no avail. Respondent filed an action for injunctive relief against PBI. PBI filed against Respondent and his mother a complaint for damages and attachment. However, Respondent filed a motion to dismiss on the ground of forum shopping and the pendency of the action for injunctive relief. A criminal case for estafa through falsification of public document was filed against Respondent and his mother. However, Respondent filed a motion to defer arraignment on the ground of prejudicial question. The issue is whether or not the pendency of an action for injunctive relief and for damages and attachment is a prejudicial question justifying the suspension of the proceedings in the criminal case. The Supreme Court said no. An independent civil action based on fraud initiated by the defrauded party does not raise a prejudicial question to stop the proceedings in a pending criminal prosecution of the defendant for estafa through falsification. This is because the result of the independent civil action is irrelevant to the issue of guilt or innocence of the accused. In the instant case, for damages and attachment on account of the alleged fraud committed by Consing and his mother in selling the disputed land is an independent civil action under Article 33. As such, it will not operate as a prejudicial question that will justify the suspension of the criminal case at bar. The independent civil action for physical injuries under Article 33 includes the crime of battery in American law. Battery is an intentional infliction of harmful or offensive bodily contact, whereas bodily contact is offensive if it offends a reasonable person's sense of dignity. It is offensive even if the defendant's conduct is intended only as a joke or compliment. Battery should be distinguished from assault, which is an intentional conduct by one person directed at another which places the latter in apprehension of immediate bodily harm or offensive acts. The Supreme Court ruled in Capuno versus Pepsi-Cola that the term physical injuries in Article 33 includes bodily injuries causing death. In other words, the civil action for damages could have been commenced by appellants immediately upon the death of their decedent Cipriano Capuno on January 3, 1953, or thereabouts, and the same would not have been stayed by the filing of the criminal action for homicide through reckless imprudence. However, there is an authority supporting the view that the term physical injuries do not include the cases where the crime committed is reckless imprudence resulting in homicide. This was explained by Justice Capistrano in the case of Corpus versus Paje, that criminal negligence, that is, reckless imprudence, is not one of the three crimes mentioned in Article 33 of the Civil Code, which authorizes the institution of an independent civil action of an entirely separate and distinct civil action for damages, which shall proceed independently of the criminal prosecution and shall be proved only by a preponderance of evidence. Said article mentions only the crime of defamation, fraud, and physical injuries. The charge against Filardo Paje was for reckless imprudence resulting in homicide and not for homicide and physical injuries. That is, criminal negligence resulting in homicide, the death of Clemente Marcia, and double physical injuries suffered by the two other persons. As reckless imprudence or criminal negligence is not one of the three crimes mentioned in Article 33 of the Civil Code, there is no independent civil action for damages that may be instituted in connection with said offense. However, this opinion of Justice Capistrano in the case of Corpus versus Paje is not the controlling doctrine, because the Supreme Court observed in the case of Madeja versus Caro that uh, the ruling in Corpus versus Paje is not authoritative. In this case of Madeja versus Caro, the Supreme Court ruled that the term physical injuries is used in a generic sense. It is not the crime of physical injuries defined in the Revised Penal Code. It includes not only physical injuries but consummated, frustrated, and attempted homicide. The article in question was the words defamation, fraud, and physical injuries. Defamation and fraud are used in their ordinary sense because there are no specific provisions in the RPC using these terms as means of offenses defined therein, so that these two terms, defamation and fraud, must have been used not to impart to them any technical meaning in the laws of the Philippines, but in their generic sense. Therefore, the term physical injuries should be understood to mean bodily injury, not the crime of physical injuries, because the terms used with the latter are general terms. This is the case of physical injuries. In Bonatti versus Zosa, the Supreme Court explained that Article 33 of the Civil Code assumes a defamation, fraud, or physical injuries intentionally committed. The death of the deceased in the case at bar was alleged to be the result of criminal negligence. Example, not inflicted with malice. Criminal negligence under Article 365 of the RPC consists in the execution of an imprudent or negligent act that, if intentionally done, would be punishable as a felony. Thus, the law penalizes the negligent or reckless act, not the result thereof. The gravity of the consequence is only taken into account to determine the penalty. Another case decided by the Supreme Court regarding physical injuries is the case of Dulay versus Court of Appeals, wherein the Supreme Court ruled that the term physical injuries under Article 33 has been held to include consummated, frustrated, and attempted homicide. Thus, petitioners maintain that Torzuela's prior conviction is unnecessary since the civil action can proceed independently of the criminal action. Neglect of duty. Article 34 of the Civil Code provides that when a member of a city or municipal police force refuses or fails to render aid or protection to any person in case of danger to life or property, such peace officer shall be primarily liable for damages, and the city or municipality shall be subsidiarily responsible thereof. The provision likewise states that the civil action shall be independent of any criminal proceedings, and a preponderance of evidence shall suffice to support such action. Article 34 is intended to afford a remedy against police officers who connive with bad elements, are afraid of them, or are simply indifferent to duty. The liability of a policeman was explained by Judge Horencio in this manner. The policeman is the government official to whom the common man usually turns for protection when his life or property is threatened with danger. To him, the policeman is the external symbol of government's power and authority. Thus, it is the primary duty of city and municipal policemen not only to preserve and maintain peace and order, but also to render aid and protection to life and property in their jurisdictions. If policemen refuse or fail to render aid and protection to any person whose life or property is in danger, they are unfaithful to their duty, and Article 34 of the Civil Code properly grants to the person damaged a right action against a recreant policeman. On the other hand, the subsidiary liability of cities and municipalities is imposed so that they will exercise great care in selecting conscientious and duly qualified policemen and exercise supervision over them in the performance of their duties as peace officers. The catch-all provisions. Independent civil action, this is in Article 35. Article 35 states that when a person claiming to be injured by a criminal offense charges another with the same for which no independent civil action is granted in this code or any special law, but the justice of the peace finds no reasonable grounds to believe that a crime has been committed, or the prosecuting attorney refuses or fails to institute criminal proceedings, the complainant may bring a civil action for damages against the alleged offender. Such civil action may be supported by a preponderance of evidence. Upon the defendant's motion, the court may require the plaintiff to file a bond to indemnify the defendant in case the complaint should be found to be malicious. If during the pendency of the civil action, an information should be presented by the prosecuting attorney, the civil action shall be suspended until the termination of the criminal proceedings. Rule 111 of the Rules of Court sets out the procedure with respect to the reservations in criminal cases with respect to the civil liability of the accused. Thus, in Section 3, when civil action may proceed independently, it shall proceed independently of the criminal action and shall require only a preponderance of evidence. In no case, however, may the offended party recover damages twice for the same act or omission charged in the criminal action. In Section 4, in the effect of death on civil actions, the death The death of the accused after arraignment and during the pendency of the criminal action shall extinguish the civil liability arising from delict, which in Section 5, judgment in civil action not a bar. A final judgment rendered in a civil action absolving the defendant from civil liability is not a bar to a criminal action against the defendant for the same act or omission subject of the civil action. So that ends my report, and thank you for listening.